no loss of funds as a contract was finally entered into, Your Honor, that in itself is by the procuring entity. Sentences, Your Honor, according to play the role of restoration, rehabilitation, denunciation, but also reconciliation, which was determined by Judge Aburili. It is on the 14th of December 2022. Yes, we have shared. We have shared the decision. They had a copy of the decision. Yes. Yes, Your Honor, in this matter, the court was touching on arson, but where the court dealt with principles, and where the Judge Aburili, an appeal which the judge upheld on the basis that the act, well, Your Honor, I'm addressing this because of the provisions of Section 137. Yes. Section 137, that if an individual is convicted for offenses set out in count 3, in this case, uttering a false and citing the case of Elisha Kipleting and Republic from paragraph 25 specific statute. Section 137, Your Honor, provides that the first option that this court has, Kenya shillings 4 million. Secondly, the court will proceed with the first option of a non-custodial sentence. Then the court states, my lord, Judge Aburili then states that if there are aggravating circumstances, then the court can consider a custodial sentence. Learned friend Mr. Whitty has submitted that the accused persons have found themselves into the record of the state. Your Honor, for the exercise of your first call of discretion, which is non-custodial sentence and a fine of not more than Kenya shillings 4 million. Your Honor, that in the circumstances, for the first, second, given the nature of this case, the time it has taken, the laborious effort that all advocates on both sides have put into this matter, the attendance of the accused person as trial, the 3 accused persons, Your Honor, are family people who have served the country and continue to serve the country in different capacities. They are senior citizens and are unlikely, Your Honor, to fall into the trap that they find themselves into this afternoon. And posted bail that is still on record. Each of the accused persons had posted bail of Kenya shillings 1 million that is on record and that is still held in the courts, just for record purposes. We will pray that the court considers a mitigation and accordingly fine the 13th, 15th, and 16th accused person cash with 500,000 on account of the proven aspect of count number 3.
Of the mode that the same was used, that the items were supplied with. Your Honor, also in this, what makes these particular proceedings before you also unique is that as opposed to other criminal trials where the complainant comes before the court and says they have suffered a certain loss due to the acts of the accused person, in this instance the complainants have benefited and continue to benefit by the mere fact that even in your finding you ruled that the complainant, having accepted the items, continued to use them to date for a purpose that is for the general good of the public. The accused persons therefore also deserve leniency, because the only mistake they did, as counsel has put across, was with the issue of confusion of documents. But the main subject of the contract was supplied. That has not been contested. It has been agreed by even the complainants. The 2-year period within which a defect clause applied also was passed, and to date, no fault has been found on the items that were supplied by the accused persons. Your Honor, they paid their statutory obligations as was found by this court. Your Honor, the overriding objective, therefore, is that justice need not only to be done, but also in these circumstances needs to be seen to be done, especially where the complainant, through their subsequent actions, ratify that which was complained of before. Your Honor, I say so because upon institution of these particular proceedings before you, the complainant went ahead and took the items that are subject of these proceedings and utilized.
Sorry, Your Honor.
I'm out of order.
Sorry.
I
plead, Your Honor, that because the court has made a finding of guilt,
okay,
that we limit it to mitigation.
Okay, I am sorry. I withdraw whatever is in contention. Without it. Which the good professor adds that they've already suffered. So, Your Honor, in closing, I would have prayed, though my senior that went before me already prayed for 500, I would have prayed for a lesser one because of the benefit that continues to accrue from what they supplied. I beg to leave there, noting the demeanor of the court.
In this trial that has indeed lasted in the court for about 6 years, since 2018. I've noted the submission. Gravity of the case and the decision and the warrant of the hand. I agree that offences relating to corruption and economic crimes are different and require differentiated treatment because of their gravity and social impact. He also agrees with the
Your Honor, Mr. Odero is jittering that you mentioned Mr. Miri instead of Odero.
my associate.
Yes, it's been a while since I did it, so maybe the names are good at mixed up. My apologies.
Mr. Neri also is there.
He's there also.
He's there.
Okay, yeah, so I agree, therefore, to grant the 11th, 13th, 15th, and 16th accused persons non-custodial sentences in the circumstances of this case. All relevant factors considered, I hereby sentence them as follows. For count 2, the 11th accused is hereby sentenced under section 48(1)(a) of the ASECA to pay a fine of 750,000. It will not be less than that for reasons that I explained in the judgment. So that is the fine. In default, he shall suffer 3 years imprisonment. Section 48(1)(b) is not applicable to him in the circumstances. The one for mandatory fine. In count 3, the 13th accused person who is a corporate entity is hereby sentenced under section 137(b). I note that indeed it is differentiated sentencing. The maximum of fines for corporate entities is 10 million. I agree that the case of the 13th accused, while it had its own perspective, is not the worst I've seen probably, but therefore I'm willing to consider that submission and sentence this corporate entity to pay a fine of 3 million. Being a corporate entity and under section 22 of the Penal Code, which apportions responsibility on the drivers of these entities, being directors or other senior officials, the responsibility to pay the fine will therefore vest on the 15th and 16th accused persons, and I'll give them 14 days to pay the fine. In default of payment, the 15th and 16th accused persons being directors, as I found, shall suffer 12 months imprisonment, which shall begin from the day of default. The 15th and 16th accused persons on their own behalf, having been found culpable, and having considered that we have sentenced them here as well, will each pay a fine of 500,000 shillings. 500,000 shillings for the 15th and 16th accused persons on their own account, and that is payable, of course, immediately after the judgment. In default, each shall suffer 12 months imprisonment. I think that is the sentence. I want to believe it's a fair sentence in the circumstances of the case. And Mr. Osemo.
Yes, you ordered that he pays a fine of 750,
Yes.
which leaves a balance of 250.
Yes.
Would the court be willing to have that 500 utilized as part of that fine so that we just pay the balance?
Yes, we always credit if he either deposited or the person who deposited comes to court and says he have mortgage.
It was cash.
It was with name.
Yes, it was cash in his
He
name.
has the receipt.
Not here, but it is a
Okay,
receipt.
so 15. If it is not, there is no problem. That is easier.
Yes. So we'll just, if it would go on the record,
Yes, I think it's an obligation that we are making at that point.
thank you.
That we apply that, and therefore the obligation is right to pay the dollars.
Or 250.
Yes.
I'm
14th, the 15th and 16th accused persons
Yes.
do apply part of the sum of Kenya shillings 1 million deposited for each of them as cash paid in court to be credited to the Kenya shillings 500,000 each, and the balance of Kenya shillings 1 million to be credited to the company. That will leave Kenya shillings 2 million